Once again, this is Steve Lombardi from the Lombardi Law Firm, and this is your legal minute for today. The thing we're going to talk about today is playing internet lawyer. I get a lot of questions from people who are obviously representing themselves after they've done a little bit of research on the internet. And I'm going to warn you about what you're reading on the internet and having false confidence that what you have learned now somehow qualifies you to be your own lawyer. They said in law school, a person representing themselves as a fool for a client, and that is probably true not just for lay people but for lawyers as well. So I'm going to caution you against doing that. And here's some of the reasons why I think you need to be careful about representing yourself. First thing is, how do you know that what you read is true? How do you know what you read is accurate? And how do you know about what you're reading, whether or not it applies in the state where your claim exists? Secondly, if you're playing internet lawyer, you have to be very careful about the statute of limitations running in your case. If you don't know the statute of limitations for the type of claim you have, you are gambling with your claim, and you could find yourself on the outs with nothing, getting nothing for what was probably a very valuable claim. So I'm going to warn you that the statute of limitations is something that will knock your case completely out, and in the event it does, no lawyer can help you. Another problem that occurs by playing internet lawyer is, in some cases, there are notice periods. You must put the insurance company, or in workers' comp, you must put the employer on notice. When there's a drunk driver, you must put the dram shop on notice within a certain period of time. If you fail to meet those deadlines, you don't have a case anymore. Your case goes by the wayside. In other words, you will be barred from pursuing that case in the Iowa court system. Lawyers who practice in the area of personal injury, workers' compensation, and dram shop cases understand these deadlines, and not just the deadlines, but how to put the employer, the dram shop, or anyone else on notice of your claim, the potential injury. The reason why those notice provision or deadlines are in place put in place by the legislature has to do with giving the potential defendant the opportunity to investigate the claim. So if you haven't given them the opportunity to investigate the claim, the legislature says you're not going to have the opportunity to pursue your claim. So I'm going to warn you, that is a very real possibility in any given case, and unless you are an attorney and practice in this area, it can be a very damaging one. The last thing I'll say about this is insurance companies like it when somebody is representing themselves because they can interview that person and get them to say things that not necessarily are in their best interest. They're not misleading, but in taken out of context, they can make you look like you don't have a case or that you're exaggerating your claim. When the insurance adjuster talks to an attorney, what the attorney says can't be used against the client. But if you're representing yourself, what you say is an admission against interest and can be used against you. If you give a recorded statement without having been prepared by an attorney to understand what you're saying, how you're saying it, and how it should be taken, you can say things without adding other things in, without an explanation, that in some instances will hurt your case. Once again, this is Steve Lombardi. This is your Legal Minute. You can contact us if you need our help by calling us at 515-222-1110, or by contacting me directly through email at sdlombardi@aol.com. Have a good day, and once again, this is your Legal Minute from the Lombardi Law Firm.